Even remarks about my body in a sexual way, it's a sexual violation which is covered in the Act. People do not know that I can open a case against you. Act 32 of 2007.
Can you please explain what you do for a living to somebody that has no idea of what your profession is all about?
Will prevent you from getting arrested. We also take you out when you are arrested. So we just on the ground. The business rescue application would be the biggest case that I've done.
Share it, please. So, in actual fact, it means that doing an LLB degree is not just only that 4 years that is being advertised there. It's literally somewhere close to 6 years for you to really
It's
be
6 years.
practicing.
It's 6 full years. A lot of people, unfortunately, do not know that you can change your marriage system. And this is something that cannot be done at Home Affairs. Only the court can grant you permission.
What's happening, everybody? Here's your favorite Mr. Cater. In today's episode, we're going to be chatting with Mugumbi Sitsura. He is a lawyer. I don't know if lawyer, attorney, counsel, judge, or what. I mean, these guys have very many names. Can you please explain what you do for a living to somebody that has no idea of what your profession is all about?
I'm what we call a legal practitioner, was practicing as an attorney, an admitted attorney of the High Court. That is what I do. With being an attorney, it means I help people. People come directly to me for whatever that they need, claims and everything, and I do all the processes to make sure that their matter gets to court in an administrative way and everything possible on the ground level, and I make sure that everything goes to court. I think briefly that's how I can summarize what I do.
Can I say you're the guys that prevents us from getting arrested?
Yes, I can say that will prevent you from getting arrested. We also take you out when you are arrested. So we just on the ground.
Yeah, because I mean, people would take it out of the context to be like, okay, so you're the guys that are saying to people, hey, do wrong things, and when you get arrested, we'll come and save you. But yeah, that's a topic for another day. You know, there is this thing that is really happening right now, and it looks like our justice system is sort of upside down. I mean, I've been having a lot of conversations with my partner here to say, hey, it looks like the police and the justice system it's just getting weaker and weaker every day and all those kind of things, right? What is just your view on that before we get to the depth of what law and being a lawyer and being an attorney is sort of about?
It's something that's very controversial, but putting this up, I would say that we are faced with a difficult time as legal practitioners in that people have lost faith in the justice system. I'm glad we're having this talk after the famous judgment which was issued today in the State versus Omotoso case, where this judgment brings a lot of public outcry in that it raises a question as to now women who are being violated, kids who are being violated, how will they come forward if matters are being presented and they are taken to court and perpetrators are not found guilty? We do know that the South African law says everyone is innocent until proven guilty, but this is just my personal view. On my personal view, I have a lot of criticism for the National Prosecuting Authority of South Africa in that the way that cases are being handled, they are not representing victims and they are not doing enough. If we listen to what the Honorable Judge said today, there was an element of coaching, a WhatsApp group where the prosecutor was telling people, stick to your story. That's something that we don't do. That's something that we are taught. You cannot coach a person to that extent when dealing with matters. So the NPA needs to do better in a way that when it presents evidence, when it presents cases in the court of law, people then come up and really will have faith in the justice system. The justice system is not a problem, but from the investigation that's done by the police on how the NPA presents cases, they produce what we call loopholes for defense attorneys. I'm a defense attorney. I know I've dealt with this on a lot of times where you see that the NPA is not really dealing with matters in the most probable way of helping clients. So for me, my view would just be that the NPA needs to do better so that victims and perpetrators can have faith in our justice system.
You know, the reason why I started from that story is so that you can just say all these interesting law words that we sort of get to hear almost every day, right? But before we we get more into the depth of that story, right? I would just like you to maybe give us a brief, right? I mean, we always hear things like the NPA, the High Court. How do those things sort of differ? Because from my understanding, it's just more of, okay, the NPA and the High Court is literally the same thing. But the way you're saying it right now, it looks like it's two different governing bodies.
Yeah, those are way two different things. These different bodies are not guided by the same regulatory bodies. When we talk about the court system is guided and it's headed up by what we call the Chief Justice, who sits in the Constitutional Court. From the Constitutional Court, we'll have the Supreme Court of Appeal, we'll have the High Court, we'll have the Magistrate Court, which is divided into the regional and district court, where there are people who are placed there to adjudicate on matters. In the magistrate court, we have magistrates. In the High Court, we have judges. In the Supreme Court of Appeal, we have judges. Also, in the Constitutional Court, we have justices who then deal with these matters. The NPA, it's a different body on its own. That the NPA, it's the state. It's a body created by the state to say that there are offenses that when you commit, they are regarded as offenses against the state. That is why if I were to murder someone, the case would say state versus Muvumbi Setsura, because that is an offense against the state. It would say state against Muvumbi Setsura, because these are offenses that you commit against the state. So the NPA is a regulatory body that is placed there on behalf of each and every person who's living in South Africa to say that we will take matters which are criminal offenses which are done against you. Then we will take these things to court on your behalf. We'll use the state resources to have forensics, to have DNA tests done, to do everything, because on our own, if something was to happen to you and you need to prosecute someone, you would not afford to have the DNA tests and everything, because you would need plus minus 200,000 rands for that case to run. For appearances, you would need another 300,000, meaning you need 500,000 for a case to run. So the NPA is the body that is placed there on behalf of all people who are in South Africa, irregardless of whether you have documentation or not. I need to emphasize that. If you kill someone who does not have documentation but they're still in South Africa, it is still an offense against the state. The NPA will still come after you. So the NPA has what we call prosecutors. Prosecutors are the ones who will then come in and then they will prosecute, they will take the cases, working closely with the South African Police Services. The South African Police Services investigate, and then after investigating, that's when they hand over the docket to the NPA, and the NPA will look at the strength of the case. After analyzing the strength of the case, that's when the NPA will then decide we are prosecuting this matter or not. If you are aggrieved as a party that the NPA is not prosecuting a matter, you can then apply for what we call private prosecution. There's a famous case that's happening now wherein the former president of the Republic of South Africa, President Jacob Zuma, has applied for private prosecution against a journalist and also against the current president of the country, President Cyril Ramaphosa. It's ongoing, but it just shows that if you're of the view that the NPA has declined to prosecute, once they decline to prosecute, they will issue what we call a nolla prosecute certificate. Then in terms of the Criminal Procedure Act, you can then approach the courts to say that you are bringing a private prosecution because the NPA did not then prosecute your case. So these are two different bodies. So that's why while we are dealing with this case, you had, like, I will give reference to the case that was handed, the judgment was handed in. The judge was criticizing the NPA to say that the work that was done was not enough because they have a very big prerogative to make sure that they work closely with the police, prepare a solid case that the court will then have to decide on. So briefly, that is the difference between the two bodies.
So basically, in this case, the judge is just saying maybe the person who was on behalf of the state, which is the people who have been who are saying this guy has done something against them, is saying that the person that is it a prosecutor or is it an attorney or a
Yes,
lawyer?
it's a prosecutor.
A prosecutor didn't really do their job right. And they didn't really go the extra length to get this whole thing. Is that what I'm getting?
Yes, in essence,
Okay.
that's what the judge said. Even though the NPA has declined to comment further on this matter, saying that they are still studying the judgment to see what they can do, whether they will appeal the judgment or not. But it's up to them to decide whether they want to appeal the judgment or not, because they have a leg to appeal. They have a chance in which they can then appeal this judgment if they feel that they have strong grounds to believe that the judge was wrong. Then they will then take this on appeal, and the appeal court will then have to decide whether the judge was wrong.
They take it from there. You know, the reason why I asked you and I sort of allowed you to come with a story the way you would like to is because most of the concepts that you guys get to use, they sound very complex. Like they just sound very complex. You hear adjudicate, prosecute. You know, it's just way too much to for a normal person to sort of consume, right? If maybe I'm asking from a point of somebody who has never heard of law but maybe is interested of it, what could be some of the important terms or concepts that you guys as lawyers use so common and would be the initial starting point or learning point for somebody? You can just name 5 of them. The reason why is because I believe we're going to talk a lot about this along the whole conversation. So if you can just give us those key points in general, then it might work out well.
I would say that there are certain terms that any lay person or any person who is interested in pursuing the legal field, these words they should know. They should know attorney, they should know advocate, they should know prosecutor, they should know academic, then they should know presiding officer or adjudicator.
Yeah, those are very big words, man.
No, these words seem big, but as we unpack them, you will see that these are simple words.
100%. The reason why I'm asking all this, right, is because there is, you know, people start when they are doing school, or maybe when they say I'm an aspiring lawyer or I want to be an attorney at some point. They always see it as if, okay, they're gonna go to school, get to learn, to practice, and then immediately after they've graduated, they're just gonna go straight to court and then represent somebody. I mean, is that a myth or is that a reality? And I mean, how does the whole process sort of goes? And then how do you even go above with those ranks when you can say you start from an attorney, you become a judge and all those kind of things? Can you just explain that small process? It's a big one. Sounds like a big one for us.
I'll try and summarize it as best as I can.
Sure.
You will study what we call LLB at any South African university. After graduating, whilst you have your degree, after having your degree, you are a lawyer.
Okay.
But you're a lawyer who is limited in that there are a lot of things that you cannot do. The term lawyer simply means someone who has studied the law. You have studied and you have qualified. You now have papers to show. But there is a lot of things that happen post studying. Let me begin with the route that I took of being an attorney. After you finish your LLB, there are 2 things that you can do. One, it's either you can look for articles,
Okay.
or you can go for practical legal training, which is referred to as law school. If you begin with PLT, practical legal training law school, it simply means that you will then register with a law school that is accredited by the Legal Practice Council. The Legal Practice Council is the regulatory body which regulates every legal aspect in South Africa. So you will go there, you are trained. I'm informed that now the training happens for 4 months. During my time, it was 6 months. After you obtain your degree, you would go for 6 months where you would be trained, you will write your exams, and then you will be issued a certificate. After issuing the certificate, that's when you would go and seek for your articles. After getting your articles are, you get them from a law firm. Law firms will advertise that we're looking for a candidate attorney. Now, a candidate attorney simply means that you have been trained under your principal, who is an attorney who has practiced for 3 years or more.
Okay.
The role of a principal is to train you on how to become an attorney. Whilst you're doing your articles, you can appear in the district court and also in the regional court, but you can only appear in the regional court only a year after you serve your articles. Now, a contract of articles, normally it's 2 years, but some firms can all give you for a year, but mostly it's 2 years. During that time frame, you will write what we call board exams, which is where a lot of people stumble and fall because they then fail these exams. Board exams, previously we used to write 4 papers, which was paper 1, court procedure, paper 2 was estates, paper 3 was legal ethics, paper 4 bookkeeping. I've been informed that as from this year, there will be 5 papers. So it means
Problems on
now
top of problems.
becoming an attorney is becoming more difficult now. They're making it more difficult.
Can I disturb you there? Because there are
Yes.
so many things that I think maybe many people would be interested to know before we continue there, right? I mean, why would I go for a 1 year and do my board exams while I could just do 4 months at LPC, Legal Practice Council? Because I think those are the 2 routes you spoke about, right?
No, you see, all those routes you need to, let me clarify this, you need to undergo all of them. It is compulsory for you to have your law school and articles. It's just that some begin with law school directly, like me.
Okay.
After graduating, I did law school for 6 months. Then I began my articles after the 6 months. That's what I did. But there are those who, there are those who immediately after graduating go for articles. When they go for articles, they will do what we call part-time law school. There are those that you will hear them saying that they are attending evening classes while they are doing law school. Because you are now serving articles, you won't have the time frame of attending the whole 4 months in class. So there will be time allocated that will then equal, or that will be equivalent to those hours which you were supposed to spend. But all those processes to be an attorney, you need law school, you need board exams. You cannot go that route without having all these two.
So in actual fact, it means that doing an LLB degree is not just only that 4 years that is being advertised there. It's literally somewhere close to 6 years for you to really
It's
be
6 years.
practicing.
It's 6 full years.
Yeah, it would be interesting to find, or maybe to get this university to tell you it's a 6 full years, right? And then the last 2 years you're actually doing like some sort of an in-serve. And then they sort of tell you, because I know some courses, they will tell you it's 4 years, 3 years at school, and then 1 year in sort of practical, and you're working for like big companies like your Coca-Cola and, you know, these other manufacturing companies you can sort of get out there. So, yeah.
Unfortunately, with the law field, the students do not know. The harsh reality begins after you graduate. You think you have made it with your LLB, and that's when life begins. Because you still have 2 more years with law school, with articles, with board exams. Those board exams are more difficult than whatever that you did in university.
Okay. So then how did you make sure you passed them yourself? I mean,
it was difficult. I won't even lie on a public platform. I wrote board exams 3 times. I failed a part of my exams. I had to rewrite because board exams are challenging. I remember my principal, I served my articles under Chirizi Munyai Artemis. Munyai told me that because you have an option. The exams are written in March or April, and August or September. It depends when they will put them. She told me, write 2 now. I remember it was March that year. Write 2 now in March, and you'll write 2 again in August. There's no rush. I was like, no, I'm writing all 4 of them now. And this is how they are written. You'll write paper 1 in the morning, paper 2 in the afternoon, paper 3 the next day in the morning, paper 4 the next day
Yeah,
in
the
the
day
afternoon.
after.
So you write 2 days, all 4 papers. So I then went through that hurdle of writing all 4 of them in 2 days. And guess what? I came back with one only passed. Three had mocked me. And my boss was like, I told you, you don't listen. But then I made amends. I went and took two in August, and I went and took the other one in March.
The
Then
next year.
I had completed my board exams.
So then now it literally took you way longer than you actually could have taken if maybe you listened in the first place.
If I had listened, it was gonna work well.
Be a different. Okay.
Yeah, but so that's the journey. After that, after when you pass your board exams, you will then make an application to the High Court. Inform the High Court that you have passed your matric, you have passed your LLB, you have done your law school, you have served your articles, you have passed your board exams, you have met all those 5 things. Then you make an application to the High Court together with the Legal Practice Council to say that you are requesting to be admitted as an attorney now. You move from candidate to be an actual attorney. That is when you will be admitted. I was admitted on the 8th of October 2020. So this year it's my 5th year practicing as an.
Which means you can take somebody under you and then they sort of can then do those things.
Yes.
Oh, interesting. And I mean, I always see you guys do. We're gonna go back to the whole journey, right? But I just wanna finish this one. I always see you guys always opening your own practices, and is that the way? Is that by design, or that is the best way to survive? Because I mean, when we look at, let's say, software engineering that I'm in, I mean, you'd literally do well by working for a corporate or for a company. And with you guys, it looks like you run away from the normal corporate way by just going and opening your own practices.
Okay. Majority of us
Mhm.
do not necessarily want to open our own practices. It's the fact that most law firms cannot afford to pay you as an attorney. They afford to retain you as a candidate attorney. Because as a candidate attorney, you get a salary that's at the scale of an intern. But now when I'm admitted, my scale has to go up, and most
Okay.
firms can't afford. So that makes people to then want to try their own hustle, push their own firms. I might say I would put it out as a hunger design
Response. Sure. I
that is
see.
there.
I see.
Yes, it's a response to hunger
It's like,
that
okay,
makes
I
you.
can't get this and I can't just be
Yes,
sitting. So let's see
I
what we
can,
can do. And then it happens to work in some way. Interesting. Interesting. I really like that. But let's go back to this very interesting journey that you spoke about, right? So now you have done this 4 months with LPC. I think you said now it's gonna be 6 months. No, you said it's gonna be, but yeah, it's gonna be 4 months, and then you have done this other 1 year as well, right? What happens from there? Now you are in, let's say you're an attorney, and then you can literally practice on your own. What happens from there as we move further? Do you just go straight to be like a senior counsel, and then you become a judge and all those kind of things? You don't really have to get to the depth of it. You can just tell us at the high level.
okay, when you're admitted, you will be what we call an attorney. But then to be senior requires you to practice for 12 years post admission. And for you to be recognized as a senior, it comes from the work that you have done, and you are recommended by colleagues to say that you have done exceptional work. That is why there are people who are practicing for 20 years and they are still not senior counsels, because they've been there for 20 years but they haven't done anything remarkable for them to be recognized as seniors in there. So that's the short of it. To be a judge, you apply. To be a judge again, you need to have 12 years minimum experience. So you will show the fields that you have done. You shouldn't be one-sided. You shouldn't be a person who only deals with RAF or someone who only deals with criminal law. You should be someone who was brought in the legal field. You know labor, you know criminal, you know family, you know what? Because as a judge, we expect you to be learned in the highest sense, because you will be placed in the family court role. And if you know nothing about family law, what is it that you are going to decide on? So that's in a short of it. That's how I
Interesting. And then, I mean, so I'm assuming the counsel is similar to it's like a senior attorney, right? Or is it like you
no no
can
no no
use
no
that word interchangeably? Can you
no
just
no
use
no no
it?
no.
Okay, what do you guys do different then? Because I mean, you would have a case, or you would have some matter. You hear, oh, hey, well, an attorney can't do that, but we need a counsel that can be able to do this and all those kind of things. How does it
Let's
work in
go.
that area?
Counsels are advocates.
Okay,
Now, maybe let me just rewind a bit. I'll try to be brief. With the attorney route, you are then taught administrative part of the legal field, and you are also taught litigation. But you are briefly taught litigation. Mostly it's admin. That's why you will hear that we'll be doing estates, you'll be doing bookkeeping. Those are administrative stuff. What else with advocates? After graduating, you will then apply to certain bars. You will have your Pabasa, you will have your Pretoria bar, you will have your RSA bar, and then you will do what you call, you will serve pupillage. Serving pupillage, you'll be trained like in the same way that attorneys are trained. You will be trained by an advocate on how to be an advocate. You will then write bar exams and also LPC exams. Then after you have done that, you will then make an application to be admitted as an advocate. Now, because you deal mostly with litigation,
litigation is appearing in
they
court, right?
it's appearing in court. There are attorneys who do not go to court totally, who deal with clients on a ground level and give everything to advocates to appear. Then there are attorneys who have enhanced their skills via trial advocacy skills like myself. I do both. I appear in magistrates court and also in the high court. But because litigation is time consuming, between running a firm and constantly being in court, those things are exhausting. That is why there are cases that I will then opt myself to say that I am giving this to an advocate. I consult with the client, I gather the information, I then prepare the file for the advocate to say, go to court and appear on this. Then I am the client of the advocate. When the advocate bills, he bills Sitsura attorneys, not the client. Then I will bill the client. The client will pay me, then I will pay the advocate. So that is how it works. So we can sort of say that advocates are litigation specialists, but attorneys can also enhance their skills, like what I did. You can enhance your skills to do both. In that,
Interesting.
you can appear in each and every court, but not every attorney appears in the high court. You need to have what we call right of appearance in the high court, which most attorneys do not have. But even when you have it, you may opt to brief on a lot of matters so that you can keep the firm. Because you can imagine if there's a 4 day trial or a 5 day trial that's running the whole week. If I'm in court for 5 days, it means the office is suffering. So it's better for me to get an advocate to go in court for those 5 days while I'm pushing other files. In a nutshell, I'm making money while the advocate is in court, but I'm also making money whilst I'm in the office pushing other stuff. So that's
Interesting.
a brief distinction that's there between us.
You spoke that you did some, rescued a business. You stopped the business from being rescued. You also you were able to take somebody from in community of property to community of property. No, in community to, yeah, to the opposite of it. And obviously you also did some trade union stuff. Can you just pick one story there that you find super interesting and then maybe just share with us? I think the in community one for me, it's the most interesting one. How is that possible?
No, I'll come to that. But I if I were to look at my matters, the business rescue application would be the biggest case that I've done.
Share it, please.
Because we're representing a client who, a business partner, then came up and applied for a business rescue. Business rescue simply meaning that the business is not running properly, and we then need to appoint someone to run the business, to say that both of us, we are fighting, me and you are partners, we are fighting, and now it's affecting the business. We'll then appoint an independent person to then come and run the business so that the business must not die. But that has severe legal implications when you talk about a business rescue, because it taints your name also. So we had to fight that application. I was working on that case with advocate Haukelo Maponya. And I remember when the case came, we had never dealt with such a thing. We spent nights of research, reading judgments. We even bought books on business rescue. What scared us the most was the opposition. They were using a senior counsel. And when we checked the year that the senior counsel, this guy was admitted as an advocate, he was admitted before we were even born, both of us. He had been practicing before we were born, so we're going up against such a person. But it did not deter us. We went, I remember it was in December 2023. We went and fought that case in the High Court in Johannesburg. And we managed to paint a story to the court to say that, listen, the business is not damaged as what they are saying. We do not need an independent third party to come and run this, because we're protecting the image of our client. And we presented a very strong case, and the judge agreed with us and granted the order in our favor and also cost in our favor. So it was quite a remarkable achievement that I always boast about when I talk about that. On your question, yes, it is possible to move out of in community to out of community, but that can only be done through a court application. We'll do what we need to do is we draft an application to the court and inform them that, listen, these people by agreement, husband and wife, they've agreed that they want to move out of in community to out. We've informed all creditors, because there are people who might want to move to try and stop paying debts which they have accumulated jointly, so that it must remain with one person to try and cheat a bond payment, or a loan, something. So you need to notify everyone. When I was doing that application, I learned that you need to notify even small creditors. For example, as clothing brands, if you have a clothing account, you need to tell them that I'm changing from in community to out. You provide reasons as to why, and that creditors won't be prejudiced in you changing your marital system.
Status.
Then the judge will assess the papers. You will then go and argue your case before a judge, and then the parties can then move out of community. They will then have a post nuptial contract signed now, which will then indicate how their marriage will now operate. A lot of people, unfortunately, do not know that you can change your marriage system. And this is something that cannot be done at Home Affairs. Only the court can grant you permission to change. If you go to Home Affairs, they will tell you, this is beyond us. Take this to court. Once the court agrees, you will go back to Home Affairs to tell them that they must update their records now, that it's no longer in community, it is now out of community.
But from the lovey-dovey point of view, doesn't that then make the whole relationship a bit weird? Because now we were in community, and all of a sudden I just wake up with the feeling that, hey, this partner of mine might do me a Judas one day, and then I want to get out of that whole thing. I mean, if we are to take law out of this whole thing, don't you think it does present such? Or how did you guys prevent it from being seen as such by the other party, if there was something you could do along the process?
That is why the parties have to agree themselves jointly.
Okay. So if the one doesn't agree,
then you will have to go for a trial. You will have to go for a trial, which it will be very difficult to produce such. It will be very much difficult for you to present a proper case, because you can't just wake up to say that this one might be a Judas. Yes, you might think this one might be a Judas, but you convince your partner that let's do this. Mostly when women men are the ones who bring or who want these applications to be done mostly.
Why?
And they want to do it mostly because men tend to have a lot of kids now outside the marital home. And now she has this fear of saying, yo, if this guy wakes up dead, I will still be expected to maintain his kids if we are married in community. Because what belongs to me belongs to you. But if we are saying that what's yours is yours, what's mine it's mine, your kids that are not mine, I have no obligation towards them.
Sure.
It's in fact I haven't seen this application being brought by a man. I'm not saying it's not there. I'm saying it's
Yeah.
I
For you have never seen it. Yeah.
I haven't. Even with the colleagues that I've worked with,
Mm.
all of them, the man just supports what the woman says. So on a lovey-dovey point of view, obvious it will be weird now because a lot of things will change. A severe decision making will change. For example, you will know that when you acquire a loan, if you are married in community of property, the bank for huge amounts of money, the bank will never give you a loan of 200,000 or so without first consulting with your partner. They're obliged to do that. You can't apply for a bond without your partner signing also.
For as long as
So
you're
now,
married, or for as long
yeah,
as you're
if
in
you are married
community.
in community,
Okay,
now
cool.
you now want to change those things to say that okay, it's fine. You can go and get your own 100,000 without me knowing, without me being notified. You see, the dynamics in the relationship do change
Everyone
a
is
bit.
just on their own. You're no
Everyone is
longer
on their
one. You're literally one on one.
Exactly. And instead of
Okay.
dividing 50-50 of everything that we have, people do
Mm.
what we call accrual system that will divide only what accrued during our marriage. Meaning that if you found me with 5 million rands and then when we divorce, I now have 6 million. What accrued was 1 million. We'll divide that 1 million into half, meaning it's 500,000.
Mm.
Then I will still keep my 5 million. But in community of property, you found me
Everything.
with 5 million. That 5 million automatically you are entitled to half of it.
Brutal, hey? Because,
Yeah.
I mean, it makes no sense because it means obviously the good things and the bad things. So if you find me in negative 2 million already, then you sort of get to accrue the very same thing. So that does the
Yes.
other contract that says we only get to own what we have accumulated after the marriage also protect maybe let's say the woman from the other kids that the guy is doing outside the marriage and all those kind of things? Or are those
Definitely.
like okay? Interesting. Because yeah,
Definitely.
because if that
It
was a problem,
protects
it needs to be
it protects
sort of
from all those
fixed.
things, including all those creditors which when you enter the marriage system they are already there.
Mm.
You are protected. You are protected from them. But in community, you are
Mhm.
not protected because now if I'm on negative 2 million, it means you are enter that negative 2 million, it's now our joint negative 2 million. You are also affected badly. That's why you find people who are working and you're surprised that this person can qualify for a car. What exactly is happening? But the truth of the matter, the reality of the matter is that they are blocked based on their partner.
Okay. Um, I mean, right now we did spoke a little bit about some very good scenarios and stuff, right? But as a lawyer, they really, or as an attorney, or as a advocate, right? Your skill really is all about: are you winning cases? Are you winning all these matters that are being brought up, obviously on behalf of your client, right? What happens in a case wherein you are you have to present something you don't believe in, or you have to then now do something that this is totally wrong, or this guy we know he stole based on his history, we know this guy stole, but he wants you to represent him in the you and stuff. I mean, is it the case where you now take out yourself and then you just represent this guy, or do most lawyers, or in many cases, then decide, okay, I'm not just gonna get into this matter and then just let it slide?
The good thing is uh, the LPC gives us what we call freedom of choice, in that I can take certain instructions and I can refuse certain instructions. You can consult with me, but then I refuse to take your case, and I'll be like, no, I'm not taking this. Then you will go on to someone else. That's how it is. I'm not forced to take your case. But you cannot take a case that you do not believe in. We are creatures of instruction. If you, Andy, you are in your room and you are locked up with your partner, and something happens, and your partner tomorrow wakes up and says that you assaulted her, and now there's a case, justice for who,
Sure.
and you have to be represented, and you come to me. One, I was not in the room. Whatever happened while I was at home sitting watching TV with my family. I don't know what happened. I have to believe what you are telling me in order for me to defend you. So that's why I say you cannot take a case that you do not believe in. I have to believe you that you are telling the truth. Your version is the truth. People will ask you questions like, how do you sleep at night after representing such a person? I wasn't there when whatever happened. I am going to present what has been narrated to me. Because even those who are now criticizing and saying, how can you represent such a person? They were also not there. It's someone's word against someone's word. So then how then do we then? It's up to the court to decide who's guilty.
I see. But then what happens in a case wherein the clients admit that they've done something? They admitted that they picked something that doesn't belong to them, right? They stole something, right? Let's say a small bar of gold or something like that. And they have admitted to you and they want you to represent. Aren't you then now a complicit of that very same crime as a lawyer? I mean, what are the laws that the Constitutional Court and obviously the NPA sort of have in place to protect you for knowing that you are representing somebody who said they've done it, but they want you to defend them?
There is what we call attorney and client confidentiality. So my conversation with my client is private. No one is entitled to it. But then, on an ethical point again, I am obliged not to mislead the court, because the day that you are admitted, you take an oath to be honest and to guide, because the role of a lawyer is to guide the court into taking a decision. I cannot deliberately mislead the court knowing that I'm misleading the court.
Okay.
So that's
So
where
what are the options then?
people
Do you
get
go
confused.
just tell the court? Okay.
No, you can't tell the court, because I'm there. I'll be killing the client and attorney confident. If a client tells you something like that, you just have to take it down with you to your grave.
So there's no way the court could force you to say, hey, you need to say it no matter what. There's no way.
They can't. They can't.
Okay. I'll move on from that, right? But let's talk about the growth that sort of happens within a journey of a lawyer, right? I mean, we spoke about different levels. Okay, this is where they move, this is where they get to, and all those kind of things. There is something that you really make shine, which is called job shadowing, which, I mean, it's a case of, okay, you go and take maybe a candidate attorney, you pull them in very close, and then they really get to see, okay, this guy does brush his teeth, he does go take a jog, and then he go represent a client at the high court and all those kind of things, right? I see you do have a few students working alongside you. I mean, do you train such on the job? And I mean, do you have anything maybe open right now that you sort of doing, and how do you do it if maybe people want to sort of get to know that?
I've been passionate about working with students because I want the students to see the practical side of the law whilst they are still students.
Okay.
That is why every time that they go for research, they go for holidays. I want students in my office for a week or two that come in, let me teach you this, let me teach you this and what. The good thing is a lot of my students that come up for shadowing, they end up coming back to me to say that, your job shadowing skills and everything worked when I was doing an interview for what. I'm now employed. I'm coming back. Hey, Mr. Sura, hey, thank you for doing this. Thank you for what. So I'm passionate with students so that they should know what the legal field is all about on a practical point of view, unlike for them to leave university without knowing anything at all. Because theory won't help you, but you need that. So we shadow a lot of students, give them guidance on how they can work as legal practitioners, and most of them end up in the space. That's how it is.
You mentioned something around the Act 32 of 2007 just yesterday on the statuses. I actually got interested, got to read about it, and it was talking about sexual offenses and any other related matter and stuff like that. And you strongly said that most of these laws needs to really be taught at church. I mean, sure, we're not saying we shouldn't really teach about business laws, but we can always teach at any given point in life. But most of these basic laws needs to really be taught at churches and then be our daily drive and stuff like that. Why do you say that? Do you have a certain scenario or case that really prompted you to say that?
Okay, I strongly believe that in any organization, be it the church, be it a mosque, wherever, such things need to be taught. Legal practitioners should be called, lawyers should be called to come and give talks about this. There is a case that currently is happening in South Africa, wherein a 7-year-old girl was molested. We are hearing stories that the police are failing to get a DNA sample from the alleged, I have to use the word alleged because he's not yet proven guilty, the alleged perpetrator. But before we even get into that, South Africa took a different change in the year 2007 when that act came into place. The change that took place was it arose from a case of State versus Masia, where someone was anally violated at that time.
Sure.
And when we checked, anal violation was not rape. So the guy was convicted of rape and they appealed that, listen, you are convicting me of something that is not a crime. Where is it? And that's what gave rise to Act 32 of 2007, in where it listed all these offenses which people do not know. A simple thing as touching someone's butt without permission, that is sexual assault. When people think of rape, they think that rape is just a penis entering the vagina. That is not what the act says only. Putting an object, putting your fingers in, that is rape. That can get you in for 15 years in jail. But people are not aware of this. People are molesting kids, putting objects on kids, be it in the vagina, be it back at the anus, but people do not know that this is rape. It's what we call rape. This is what I believe should be taught. People are having their breasts touched, their thighs are being touched, be it male, be it female, and they do not know that these are acts of sexual assault. Even remarks about my body in a sexual way, it's a sexual violation which is covered in the act. People do not know that I can open a case against you for making such remarks about my body in a sexual way. So it is broad in a way that people do not know these things, and that's why for me I have this outcry that yesterday on my status I gave example of a church, that the church should come in handy and project this, because I believe that a church has audience that you can easily get through to them. But also other platforms, if people have other platforms like this, they help. When someone watches this, I'm sure when someone watches this, they will be shocked to hear that someone making remarks about your body is sexual violation. Most people do not know that. They'll be shocked to know that you can open a case about such things, and people need to be taught and know these matters.
And I mean, the role of church for me, I really like talking about this because, I mean, you and I can easily say we grew up in church, right? It's because it's evident that people sometimes get to even listen to their church leaders more than even their family or anyone that is very close to them. So then if that is a medium of communication and that is where people really get to start, I think it would even sink a bit more in, and then we sort of have this rule gets embedded in our heads very easily. But if such programs have to be done, right? Do you have a way you would suggest this can be done? I mean, the reason why I'm asking, right, is because I'm super interested to take out these chats that we are having here, CommuniCator Chats, not only on YouTube, but also on the street. Let's say we have, they call it a sort of road trip, and you sort of go visit. You just say, okay, we're going to go to this one side, either schools, either churches, wherever, any gathering that people get to really know about, maybe career in general. We can have like lawyers and doctors and all those kind of people. They come with different views and all those things. I mean, how would you suggest such programs gets introduced? I'm asking for myself as well.
That's the way
Like in the
that you have
real
just
world, like on the ground.
the way that you have just sorry the way that you have just painted a picture. It's how such programs should be introduced. I remember in 2022, is it 2022? I was invited a series of churches down there. I was at home at a village called Pire, but it was a group of churches. My church was one of them. I was invited by one of my pastors, Reverend Konani Maseresere. It was a couple's get together. And that day they wanted me to address them on the marital regimes,
Issues.
systems, consequences of marriages. I was addressing people who had been married for 20 years who knew nothing about what the law says about marriage. They're just there for 20 years. But it was a nice cozy event, romantic event with lights on. It wasn't a sort of church service, but they were even playing romantic music. It wasn't gospel music. What? It was a nice cozy event. They were at it was at church, but they'd taken a bit of church out and they'd set up the theme for the day. You see, so that is what I believe with young people. If you can just have a chillers, we sit down, talk over food about such things on a round circle, and we have such discussions. These discussions play a big role, but we're still doing it in the church. For me, I refuse for the church to be only there to tell us about heaven, hell, and what we are living on earth, where there are practical problems that we are facing now. The church needs to be involved and let us
Every
know
day
about things which are happening now. Career guidance should start at church. Businesses should
at the
start
church.
at church. We should talk about those things there because we have a greater audience. Unlike, I'm not saying there's anything wrong, but churches should not only not be about talking about Paul and Peter and Abraham. Let's talk about the current events which are happening on the world.
Yeah, I mean, it would be a very difficult case to convince some other pastors who just want to program people to give them money to say, hey, let's talk about marriage, let's talk about finances and all those kind of things, because they'll be like, hey, this one wants our people to wake up and not give us money anymore. But
Eh,
yeah, I think if such program starts, then it will start singling out those other leaders who might not really want to see the best for their people in some way.
yeah, that's when that would help a lot.
So I mean, we have things obviously like bullying and assault and stuff. I think maybe most of them we can just really talk about them in those events that you're talking about. I'm very much interested in organizing some of those, or get people who can organize events better than me to actually do it, because I do think, more especially these days, we are living on shorts. Like, we are just living on scrolling on TikTok, and we're not really getting the real things that really giving us this meaning in life. Okay, if you are to look back in your life, right, from an attorney, a lawyer point of view, are there any decisions maybe that you might have taken that you wouldn't take, or you would sort of get to do better, and probably wouldn't want somebody else who's coming after your footsteps to sort of follow them? Or some of the biggest mistakes you've done? Let's say maybe you have done you went to study something else that doesn't necessarily correlate with what you have to sort of have in your field and stuff like that.
I would say that the biggest regret I would have is not registering for my master's immediately when I finished my LLB.
Okay,
That would be one of my biggest regrets.
I see.
because
I see.
it's very much important for you to be. There's an old myth that's there that says that only people who do masters are those who are going into academics. And
Yeah.
that's not true. You need to enhance your skills more. I began enhancing my skills at a later stage.
Once you get to that point where you know so much of the theory, and then you're sort of difficult to be taught the practical stuff if you get to be too much of an academia at an early age.
No, it's not. I know there are people
Okay.
who have that. There are lawyers who have that thing that when they advertise for articles and they say someone who has masters and they're like, hey, no, this one thinks they know too much. I'm not going to take them. This one will be a problem for me in my firm because they think they know. But you might find those people come in and then tend to be a valuable asset to the practice.
Do you have any specific advice maybe for, let's say, for a kid who is in high school, or who is in high school, who's thinking that they want to do this law thing and they're sort of preparing themselves? And I mean, what do you think they should sort of take a look at? Because it looks like in many cases people don't have no idea. Sure, they know they want to do this, but they probably have no idea where to start, where to not start.
What the advice I would give them is that they should know that they with law takes time for you to make it. It's not only the 4 years, it's 4 plus 2 years. Either you are becoming an attorney or an advocate, it's 4 plus 2 years.
Beautiful. Thank you very much. I did hold you up for some time here, but I believe this time was quite productive and super fruitful to you, and as well us and the viewers as well. So yeah, thank you very much.